Every single thing that you say on the phone is recorded.
I know that, so why would I be on it threatening people?
We'll find out. I think that you are continuing to threat to the public even while being in jail.
What criminal?
I don't want you to say anything. That's okay. We're going to find out because I'm going to have them pull all the records, pull all the phone calls, and we'll listen to everything.
Okay, but I can't call nobody. Literally nobody. So what? There's no TV in my tank. There's no nothing.
All right, everyone. Today we're looking at Judge Fleecer presiding over a case involving a 19-year-old defendant facing several aggravated assault charges. On top of that, he apparently thought it would be a good idea to threaten the witnesses in his case while he was sitting in jail. That's a pretty bold decision, but in Judge Fleecer's courtroom, there's zero tolerance for behavior like that. In this situation, the 19-year-old complains about not having his phone and says there's no TV, basically acting immature about the whole thing. But this case also serves as an important reminder that witness intimidation is a serious crime and can lead to even more charges, especially in a case like this. What are your thoughts on this court case? Let me know in the comments below. And if you like content like this, be sure to like and subscribe. Let's jump right into it.
Come on, man. I'm itching to
Give me
go
approach,
play.
Judge.
Whatever happened with Mr. Wiggins?
Mr. Wiggins has some bond conditions to not speak to the complaining witness in an ag assault with a deadly weapon and an ag assault family member. He then went to jail and called her twice and her mom.
I mean, what more can we do? Really?
Take the phone away.
Oh, yeah, that's a good point. We'll do it now.
He also called not only under his own name, but he also called under 3 other inmates' names.
Good morning, Mr. Wiggins.
What?
How's jail?
Cool.
It's come to my attention that you are violating the conditions that we set out in this court, flaunting it, and trying to get a hold of the complaining witnesses in these cases when we've told you not to. Go ahead.
Yes, Judge. The deputy called me this morning and said that the defendant has called the complaining witness twice and the mother of the complaining witness as well. The deputy told me that while listening to these phone calls, he heard the defendant and say things such as, "This is how you take care of things," and that everybody violates their bond conditions and talks to the complainants in these cases. He also heard the defendant make statements saying that he was going to continue to violate bond, and once he gets out, he was going to hire an attorney, but he had previously learned that the defendant was indigent, and so he took this to mean that the defendant was going to commit other criminal acts to get money to hire.
That's honestly unbelievable to me. Not only is he threatening the witnesses in his own case, but he's also basically admitting that he's planning future crimes. How can someone be that reckless? Seriously, this guy isn't making smart decisions at all, and I can't wait to see how Judge Fleecer responds once the prosecutor lays everything out. But I want to hear what you all think. What do you believe Judge Fleecer should do while this defendant waits for trial? Personally, I'm not sure what more they can do besides taking away his phone, but I'd love to hear your thoughts. Let's jump back into it.
The other courts as well, better so that they know as well.
Yes, Judge. I just sent a full email to the felony prosecutor in case the deputy hadn't already alerted her. I just went ahead and did it. The deputy, again, is getting the transcripts for these calls, and that the defendant has been using 3 separate inmates' spin codes. That would be Jermaine Brown, Mark Diaz, and Dennis Compton.
Your privileges are hereby revoked. You are not allowed to use the jail phone at all from now on. Do you understand? I think that you are continuing to threat to the public even while being in jail. So your privileges to use the phones at all are hereby revoked.
Judge, I just,
You
again,
just told you.
Not even.
please stop.
So
And I just want to read.
please go ahead.
He's
Yeah.
19. You are taking away his ability to communicate with his family.
But he's making additional threats allegedly, you know? Okay, we're going to get the records, but
Okay.
until I know that you're not a threat, I mean,
He's typing everything
Every single thing that you say on the phone is recorded.
I know that. So why would I be on it threatening people?
We'll find out. Because I'm going to ask you, could you mind please pulling all the records, getting all the phone calls, and we'll play them out here in court and we'll see. And if it's not, then I will gladly give you your phone privileges back. But there have deputies that have pinpointed you allegedly, you and using other people's spin numbers to make phone calls, to make continuing threats, and to further.
Here it is rewritten with the same meaning and tone. I honestly kind of feel for the defense attorney in this situation. You can tell she's having a tough time. It's clear she knows there's really no solid way to defend someone accused of intimidating a witness, but she still has to put something on the record. And her main point is basically that he's only 19 and needs to stay in contact with his family. The problem is, that argument isn't likely to carry much weight in court when he's allegedly threatening people while already facing assault charges and associating with gang members. At 19, you're definitely old enough to understand the consequences of your actions, especially when it comes to breaking the law. But what do you all think? Is the defense attorney's argument reasonable, or should Judge Fleecer come down hard here? Let's get back into it.
That's okay. We're going to find out because I'm going to have them pull all the records, pull all the phone calls, and we'll listen to everything.
Judge, I will also say that the defendant told the complaining witness, this is about the ag assault involving the firearm, that when she got shot, the defendant said that's what happens when you hang out with gangsters.
So pull all that stuff, and all that stuff gets so we need to figure out how, because it's a first for me as far as doing a revocation of privileges like that. As far as revoking phone privileges for inmates,
as far as I know, it has to be through the court order.
Okay. I need to do whatever I can because it's apparently a problem now. So I guess I'll reach out to administration as well to figure out how, because it's a first for me.
Judge, just so we're all on the same page, Mr. Wiggins is obviously going back to the jail now. Even before that order is in place, you are instructing him now not to use the phone. So.
No.
So I did do that's so stupid.
Well, we'll get the tapes and.
Get it? We'll see.
Okay, but I can't call nobody. Literally nobody. So what? There's no TV in my tank. There's no nothing. What am I supposed to do?
It's jail.
What's the point?
Read a book.
There is no books. I read every book in there.
Yes.
Okay. I can't trust you to use a phone, Mr. Wiggins. You know what's happening. I have other deputies that have alerted us to what's going on. I can't. That's it. You got to know when you're in the jail, there are eyes all over you. It's like at a casino. You literally have eyes all over you at all times. You got to know that whatever you're doing is always being looked at.
Stay in bed. That's why I wasn't threatening nobody. I didn't say anything.
He's typing everything
then
that you're saying.
Asking them
I
to pull it.
understand. He's talking about I'm doing illegal things when I get out to hire a lawyer and all these other things. That's stupid. I never said anything about anything illegal. That's just.
What do you all think about this case? Was Judge Fleecer being too lenient, or was there really nothing more he could have done in this situation? Sure, taking the phone away might temporarily stop the defendant from threatening witnesses, but does that really address the bigger problem? I'm not so sure. It doesn't seem like this guy is learning from his mistakes, and it's frustrating to watch someone keep digging themselves into a deeper hole. Realistically, though, when someone is facing multiple charges and continues making reckless decisions, the odds are definitely not in their favor. The legal system doesn't take witness intimidation lightly. It's a serious offense that can add even more time to a sentence. At this pace, it almost feels like he's setting himself up for a very long stay behind bars. Do you think there's still a chance for him to turn his life around, or has he gone too far? Could he end up spending the rest of his life in prison? Share your thoughts on this hearing in the comments. Was Judge Fleeser's decision fair, or would you have handled it differently? Thanks so much for watching. If you enjoyed this video, don't forget to like and subscribe for more content like this I post every single day. I appreciate all of you. Take care, and I'll see you in the next one.